Number 32, the people of the state of New York versus Yusuf Sparks. Thank you, Joe. Good afternoon, counsel.
Good afternoon, Your Honors. Before I begin, may I please ask for 2 minutes for rebuttal time, please?
Of course.
Thank you. May it please the Court, my name is Andrew Dalek. I'm here on behalf of the appellant, Mr. Yusuf Sparks. Mr. Sparks went to trial with one defense, and one defense only. And that was on December 21st, 2012, when he picked up an empty milk crate and struck Mr. Reginald Randolph, also known around the neighborhood as the Punisher, over the head.
So can there be a reasonable view of the evidence in support of that justification defense if he's outside and he walks back in and asks for a stick to beat up Mr. Randolph? And when the manager of the store refuses to give him the stick, he gets the crate. Where does that fit in?
Okay, so that chronology can't be taken apart from the rest of the video and the rest of the evidence that was presented to the jury.
I watched the video. It's pretty damning, I thought. It was pretty difficult to see the argument for justification in that 5-minute sequence, the central part that we're really talking about here. I looked at, there was no attempt to retreat. There was no initial aggression. If there's some area that you want us to look at, point us to where you're talking about, where it's in the video that would substantiate a justification defense.
Sure, Your Honor. So to take those two questions together, the reasonable view of the evidence in the light most favorable to Mr. Sparks in this context isn't in a vacuum. We don't just look at those 30 seconds in which he picked up the milk crate and struck Mr. Randolph in the head. We have to look at what happened minutes before that event. And what the reasonable view of the evidence in a light most favorable to Mr. Sparks asks the trial courts to do, and its gatekeeper role in this case is to say, could a reasonable juror have had a reasonable doubt that Mr. Sparks acted in self-defense, given the following?
The jurors saw the video, correct?
The jurors saw the video, yes. But assuming the following to be true. So could a reasonable juror have had a reasonable doubt assuming all of the following to be true? First, that Mr. Sparks was aware of Mr. Randolph's reputation in the community for being a violent crack addict whose nickname is the Punisher and had seen Mr. Randolph rob and assault others in the past. We have to assume that to be true. We also saw from the video that Mr. Randolph was behaving throughout the course of that morning in a very erratic, belligerent behavior. Indeed, when Mr. Sparks was standing outside of the bodega initially, and Mr. Randolph lurched forward at him and another person standing out front of there, pardon the expletive, but he yelled at them, and this was clear on the video, "I'm going to fuck you up, I'm going to fuck you up too." And he threatened them outside of the bodega. That's uncontroverted, and we also know that to be true.
My problem with the litany you're about to go through, though,
Yes.
is that he leaves. Yeah.
Yes.
He leaves safely. He goes, eats some chicken.
Right.
And then he comes back.
Right.
He could have just continued on home.
Well, he could have, Your Honor, but he still needed to go back to the bodega to get the medication that his great aunt needed.
That's the problem, isn't it? He didn't need to go back to that store. Was that the only store he could have gotten Tylenol from?
Certainly not, Your Honor, but the question here is he only returned to that store, and he testified to this, after he saw that Mr. Randolph was no longer there. So the issue for him was he was confident that Randolph had left. This is only minutes after the altercation inside the bodega, in which we have to assume again that this is true.
Randolph was outside walking around in the video. He was sort of walking in a circle, looking kind of dazed on the video.
Well, he wasn't just walking in a circle at that moment. There were other patrons outside of the store that were out there as well, and they kept a very healthy distance from Mr. Randolph. The jury saw this too. And from Mr. Sparks' vantage point, he testified that when he was back inside the bodega, he didn't know what kind of an imminent threat he was facing. And the penal law envisions a situation in which a person can, if they are subjectively afraid that they are about to face an imminent threat.
Didn't he, as he's walking into the bodega, ask for the stick?
No, not until he actually saw Mr. Randolph reappear.
So how long after he walks in does he make this request for the stick?
A matter of...
When does he say, he's out there and I'm afraid again?
Very shortly thereafter, maybe a half a minute. So again,
Counsel, setting aside the defendant's subjective belief, describe for us the threatening behavior of the victim outside the store in a light most favorable to your client?
At that moment, we can't divorce that objective inquiry from what transpired minutes before that. And we heard on the video, so setting aside Mr. Sparks' testimony for a moment, we heard on the video, because again, there was no video footage from within the bodega, it was just auditory. But we hear Mr. Sparks distinctly yell, "Take your hands off of me." So for the purposes of the inquiry, we assume that Mr. Sparks' testimony is true, that Mr. Randolph was trying to rob him. But setting that aside for a moment, it's clear that there was some sort of an altercation that was instigated by Randolph inside of the bodega in which he put his hands on Mr. Sparks.
Didn't defendant knock him out and Randolph leave?
A knocking out is a very strong term, Your Honor. I believe that Mr. Sparks pushed him to the ground and left, and then only came back when he believed that Mr. Randolph wasn't there. But, Your Honors, let's assume for a moment that you're not inclined to find that Mr. Sparks deserved the justification charge. He still gets a new trial because the court permitted the prosecution to cross-examine him on the extremely prejudicial details of a prior robbery conviction that had no probative value whatsoever as it pertained to the justification defense, and certainly had no probative value given the fact that the court refused to charge justification. So this was sort of an unconstitutional catch-22 that the court put Mr. Sparks in. When Mr. Sparks testified and essentially laid out, from his perspective, why he was subjectively afraid of Randolph that night and left it to the jury to decide whether or not that fear was reasonable, the court instructed the prosecution, after having already decided that she wasn't going to allow the details of this prior robbery conviction to come in, that if on cross-examination Mr. Sparks insists that inside the bodega Mr. Randolph, when the attempted robbery occurred, by Randolph against Mr. Sparks, that if Mr. Randolph was the initial aggressor in that context, she was going to allow in the prejudicial details in order to rebut his justification defense. So at that point,
Doesn't she let it in to show that he's fabricated, or to let the jury determine whether or not he's fabricated the story that, or his version of those facts, that Mr. Randolph attacked him in the same way that he himself had been found guilty of committing a robbery?
I see what you're saying, Your Honor. Well, even assuming that's true, New York's rule is very specific in either the Sandoval or the Molyneux context. In the Sandoval context, once a definitive Sandoval ruling has been given, and the defendant has chosen to testify based off of that Sandoval ruling, he can open the door to allow the prosecution to go beyond the scope of that Sandoval ruling if the precluded testimony directly refutes his direct examination. We don't have that here. Nothing about the details of the prior robbery conviction directly refute his subjective fear that evening of Mr. Randolph. In the Molyneux context, it's a similar inquiry. We start from the position where the details of the prior conviction are inherently prejudicial. There's no question about that. So the court has to ask, does the probative value of this evidence outweigh its naturally prejudicial effect? Here, we have the same problem. When the court allowed the prosecution to introduce the prejudicial effects, or the prejudicial details of this prior robbery conviction, she was essentially saying, this is elucidative, this is going to elucidate Mr. Sparks' subjective intent that evening. But in People v. Bradley, this court was very clear. The information has to be demonstrably probative, demonstrably relevant to that subjective fear. In Bradley, we had a situation where the defendant had asked for a justification.
It could not be used to show fabrication?
No.
It could not.
It could not be used for that purpose. That was erroneous. And even if
The circumstances were different in Bradley, though. That was 10 years before, right? It's the thigh stabbing incident.
It's the thigh stabbing incident, yes, Your Honor. But
Here's the problem with the argument, the Sandoval argument. Let's say the court releveling the playing field in some senses was error. How is this not harmless error in light of the video, which seems to be overwhelming evidence?
Well, first, the video isn't overwhelming, and the evidence, as taken as a whole, wasn't overwhelming because the jury acquitted Mr. Sparks of the top count and convicted him of the other.
I don't know if that may have been a rational decision on the jury's part, between serious physical injury and physical injury.
And also as to what Mr. Sparks intended that evening, right? So what Mr. Sparks' intent was obviously something that the jury was seriously considering, and the evidence in and of itself didn't preclude a finding that Mr. Sparks intended to inflict
So
physical
you're saying
injury
it's
versus
not
serious
overwhelming
physical.
because, in essence, because they didn't convict him of the top count?
Well, that's one of the reasons why it's not overwhelming. Another reason why it's not overwhelming is because Mr. Sparks' justification defense was meritorious. The jury should have been allowed to answer the question, would a reasonable person in Mr. Sparks' shoes have felt subjectively afraid of an imminent threat coming from Mr. Randolph such that it was necessary to essentially effectuate a preemptive strike, which the penal law envisions in these kinds of situations to ameliorate that threat. The problem that we have here is that when it comes to the evidentiary issue, the court tethered that evidentiary ruling to the justification charge. And so at the moment that the court does that, it essentially says there is enough evidence here for the jury to really debate to an extent about justification. And then it says, you know what, after the fact, after having let these details in, I'm not going to give Mr. Sparks the justification charge. He got the worst of both worlds and deserves a new trial.
Thank
I'll
you,
save the
sir.
rest for rebuttal. Thank you.
Counsel?
Good afternoon.
Good afternoon.
Your Honors, the reason why the jury was not given the option of making a factual determination here is that there was no factual determination essentially for the jury to make, because when the judge looked at the defendant's testimony and credited it as a matter of law, it did not make out justification. Several of the judges have referred to that video, which I think actually, really speaks for itself. The video shows that at the moment that the victim he was assaulted, he was simply standing outside the bodega. The defendant, even if you credit his story that the victim attacked him inside, which there's reason not to credit, but let's say you credit it, the defendant is seen coming out of the bodega with a milk crate in his hand, and he just clocks the victim on the head. Now,
But if you credit his testimony, he said that he did that because, given all the things he knew and all the things that had happened, he thought that this guy might have had a gun and that he was in imminent risk of
But
being
Your Honor,
injured.
there still has to be an objective basis for believing that the victim has what you say has a gun. The victim was standing outside at that point. This was way after the claimed attempted robbery in the bodega, so that.
But assuming that he had to leave, he had to walk out that door at some point, and he gives all these reasons why he feared that he was going to be attacked.
They still have
Why does that eliminate any
Because they still have to be
possibility for a jury?
objectively reasonable. He could, in other words, he can't say, gee, I was afraid of this man who was just standing there doing nothing, and if anything, looking drunk and dazed, because I've heard bad things about him, or he did bad things. There has to be an objective reason why he believes the victim's actually going to do something to him rather than the victim just standing there. And I think it's very instructive that in the defendant's reply brief, he talks about this as a preemptive action. And there are circumstances, I suppose, where you can use preemptive action in self-defense. If someone's pointing a gun at you, if someone
But
lifts a bat.
what if he was in the store, he knew this guy, they were rival drug dealers, and he knew from the talk on the street that this guy was out to get him, and the first time he laid eyes on him, he was gonna kill him.
I mean, that would essentially do away with the defense of self-defense. There has to be an objective reason for why the defendant fears at that moment, as some of the other judges have pointed out. There were millions of things he could have done. He did not have to walk out and immediately hit the victim on top of the head with a milk crate. That was not his only option by any means. And he can't justify it by saying, I was scared of the guy because he has a bad reputation. He said some nasty things to me. There
I
has
think,
to.
I think the concern is, why is he walking back in? And counsel says you have to credit his testimony that since he no longer saw Randolph around and he still needed to get I think it was Tylenol for his great aunt or whatever it was for his family member, that he went back to get that. And only once he's inside and there's only one exit, that door, that front door, he then sees that Randolph has returned, and a certain amount of time has elapsed, and he doesn't know if Randolph, who is a drug addict, there's no dispute about that, people don't dispute that, may have perhaps further armed himself or is now a very serious threat to him. So the point is, if you're crediting that version, why isn't that version, as we must, right, he's saying, why isn't that objectively enough to get the
Because
justification charge.
it's not objectively enough as a matter of law for the defendant to be in the store and see the victim just standing there and say, I'm afraid he has a gun. Perhaps if Randolph had had a bulge in his waistband, perhaps if Randolph had moved in some way, all you have, and this is according to the reply brief, if you really examine it closely, the only action that was taking place outside at the time the victim was assaulted was that Randolph was lurking. And this is the description given by the defendant.
But aren't you taking that, just one little piece of testimony out of the whole scenario that
But it's the most important piece. In other words,
But you don't get to select that, right? The question is whether, given the testimony and the evidence viewed in the light most favorable to the defendant, is it possible that the jury could have found?
and I think the judge, as the gatekeeper here, had an obligation to take the evidence in the light most favorable to the people, which she did, and reach the legal conclusion that on these facts, whether the defendant had a subjective fear or not, there was no objective basis for the assault. In other words...
And counsel, there is an objective component to this analysis, right?
Yes.
And it seems that some of the trouble is the distinction between an objective component, and here you have a very objective film, and the light most favorable to the defendant, which doesn't seem to equate to me to accepting the subjective view of the defendant as objective. I mean, there's a difference there.
Well,
It
what
doesn't.
you're saying is that we have to accept that the defendant may have subjectively had fear.
Right.
I think that's true.
That's a difference between objective evidence.
Right, but still, if the defendant had come out and had a bazooka in his hand and, used it against Mr. Randolph, who was just standing there, he may very well have feared Mr. Randolph subjectively. We give him that in the legal analysis. But there still has to be an objective basis for the fear. And if you look at the video, all you see is the victim standing there and the defendant coming out and clocking him with the milk crate.
What about
Now,
Mr. Dalek's last point, that there's something fundamentally inconsistent about the judge hearing the testimony and then saying, I'm going to allow the Sandoval material because it is related to justification? She must have thought there was sufficient grounds then to give a justification instruction, and then refusing to give a justification instruction.
Okay, I think one of the issues here is that everything has sort of gotten lumped together, and a lot of these rulings happened at different times of the trial when different evidence was being presented. The judge originally made a Sandoval ruling. Then, at one point, the defendant suggested that he might put on a defense witness. She made another ruling, but she never actually let him question the defendant about the prior conviction until the defendant actually took the stand and testified that the victim did to him what he had actually done to someone else.
But she explained her reason for doing that as relating to the justification defense, right?
Well,
At the time.
The reason she did was this. First of all, I think you have to realize that a judge can't make a ruling on a justification charge or any charge until she heard all the evidence. At the time the defendant was being cross-examined, the case wasn't over. So actually, if at that point the judge had said, you know what, you have no justification charge, then of course the defendant would have objected, but the evidence is not all in, so she had to make
But once he testifies, you've seen the best case scenario for him, haven't you? I mean, it's his version. He's now explained his subjective belief, and he's given his chronology of what has occurred. So I mean, on cross, all the people are going to try and do is knock that down and make it look worse. So
But
you
she's
heard the best version from his side.
She's being asked, the judge in this case, to make a very specific evidentiary ruling. And the evidentiary ruling she makes at the time that she makes it has nothing to do with the Sandoval, really. It has to do with Molyneux, because what happens, and again, if you look about 3 or 4 different junctures in the case, this judge repeatedly would not let the defendant be cross-examined about what the prosecutor wanted to cross-examine about. It was only when the defendant on cross-examination says that the victim did to him exactly what he's done in the past that
You're
she
saying
said.
it's to show fabrication.
To show fabrication, and the
What,
reason...
what does the judge say to make clear that that's the choice being made?
Well,
Is there something at the time? Is there something in the instruction, a combination of both?
Yes, the judge actually indicated at various points that this was no longer Sandoval, and the reason why it was probative, contrary to what my adversary is saying, is that this is not a case where the defendant was accused of robbery, so the people are asking to introduce a prior robbery on some modus operandi theory, to show that he commits robberies. This is an assault case, and the fact that in the past the defendant was himself has committed or was convicted of an act that he's now ascribing to the victim certainly goes to the credibility of his claim that the victim actually did it. It's a very bizarre thing, very uncanny thing. Certainly the jury was entitled to know that, not to show that the defendant had a propensity to commit robberies, but to show that his version, or to help judge whether his version was
Does the
credible.
charge reflect that?
I believe so, Your Honor.
Does the judge say you can't consider this for propensity? It
The
goes
judge
to
did say
credibility?
that. On page 39 of our brief, the jury was told that the only purpose that they could use this was on the degree of credibility you wish to give to the trial testimony. So she made very clear that while this was probative of something, they could not use this in any way to assume that the defendant had a propensity and that it was only on the matter of credibility.
Did the defendant object to the charge?
I don't believe so.
Thank you.
And even more fundamentally, the fact of the matter remains that in some ways the evidentiary ruling was moot because for the very reason, as I began my argument, if you have the defendant on the video striking the victim over the head with a milk crate with absolutely no provocation at the time and no justification, there's no way this ruling could have made a difference. So we'll stand on our brief and ask you to affirm the appellate division. Thank you.
Thank you, counsel. Mr. Dallek?
Thank you, Your Honor.
Counsel, the defendant's argument that when he's inside and he chooses to pick up this milk cart crate and come out and hit Mr. Randolph, that he thinks Mr. Randolph is going to come in, or it's the only way he thinks that he can get out?
Both. Either way, he doesn't know what the imminency of the
Because
threat
if
is
Mr.
at that
Randolph's
point.
not coming in, why can't they just call the cops? Or why can't he wait it out?
There were
Randolph
many.
left before.
I guess there were many different options in front of Mr. Sparks at that time, but that is a question for the jury to decide concerning the reasonableness of his action. I think the problem with the people's iteration.
Counsel, I have a couple of questions about that for you. It seemed to me from watching the videotape that everybody involved in this was familiar with the bodega owner, and he was familiar with the actors involved, Mr. Randolph, your client.
Yes.
And in fact, I think he called him Joseph.
Yes.
So I realized that there was one entrance into the store for patrons to come in and buy things, but there must have been another exit from the store out the back or something. So if your client was really afraid of Mr. Randolph, couldn't he have asked the bodega owner, let me go out the back way instead of going out the front way?
There was no testimony about an alternative entrance
Exactly.
adduced at
He
trial.
wanted to go out the front way. If he was so afraid, he could have, what my suggestion is that he could have gone out a different way if he wanted to avoid Mr. Randolph.
Sure, but that again goes to the weight and credibility of the defense as a whole.
But
Right.
doesn't he have the requirement to retreat if he wants to have a justification defense?
I don't believe that there is a duty to retreat under Penal Law 3515 as it pertains to the use of physical force. I believe that duty to retreat pertains to the use of deadly force. And so to the extent that he requested an instruction regarding the use of physical force, there's no duty to retreat embedded in there. Again, part of the tragedy here is that all of these questions go to the weight and
Let's take his version again. So, and view it objectively, the objective component of it. So his version, as I understand it, is he goes in, he asks the bodega owner manager for a stick, and that person says no. Doesn't that objectively tell us something about whether or not the defendant's response is justified?
Well, it might mean that the manager wasn't afraid of Randolph, but Mr. Sparks was. And I mean, and that again just goes to the weight and credibility of Mr. Sparks' justification claim. The problem here is that all of these questions sort of implicate the core issue, which is, when is a defendant entitled to a justification charge? And the people's iteration of this standard seems to be a defendant is only entitled to a justification charge when his justification defense is meritorious. That's not the rule in New York. The rule in New York is the reasonable view of the evidence, but taken in a light most favorable to the defendant.
And done in such a situation, if then the evidence belies the justification defense, would you agree that then there's no error if the judge chooses not to permit the justification charge?
Certainly, but that gatekeeper role is limited, and this court has said so in People versus McKenzie, to patently insufficient claims in which there is nothing but a speculative relationship between the action taken and a triggering circumstance. We don't have that here if you take the evidence in the light most favorable to Mr. Sparks for all of the reasons that we outlined in the brief. He had an altercation with him inside the bodega in which Mr. Randolph tried to rob him. He had seen him rob and assault others in the past. Mr. Randolph had lurched forward at him and attacked him when he was outside of the bodega, and then
Can
Mr.
you address
Sparks...
the question of the charge? Your light has gone, so it'll be my last question. The question of the charge, right? The ADA says the charge makes clear that on the second point.
Yes,
that
concerning the evidentiary
The information
ruling.
about the robbery comes in to show fabrication, not propensity.
Well, there are two things there, if I may. I understand the red light is
May.
out. The first is that the court's instruction is incomplete to the extent that it notifies the jury, you've learned that the defendant has previously been convicted of a crime. They didn't just learn that. They learned that 2 years prior to that, in a totally unrelated instance, my client went up to an unknown stranger, total stranger, and pretended to have a gun and threatened to kill that person and beat her up. They learned that. They didn't just learn the existence of a prior conviction. And the court, tellingly, at the very beginning, before the jury was paneled, when this was sort of happening pre-trial, said that that information was useful to discerning whether or not my client had a propensity to act with violence with little or no provocation. That is the extent to which the court admitted it, because she wanted the jury to know that this was a bad dude who was probably not really afraid of Mr. Randolph. And for that reason, if we don't win on the justification defense, we should win on the evidentiary ruling. If we lose on the evidentiary ruling, we should win on the justification issue.
Thank you,
Thank you.
Counsel.